Well, I am very honored to have my longtime friend. I feel like I've known you since we were kids because we come from
I was a
literally.
kid, not so much you.
That's right. That's right. That's right. Well, you married a girl that I went to high school with, so there you go.
Yeah,
It's in that realm, right? That's the way we.
yeah. It's a nice
Harris.
long relationship.
That's right. Harris and I have been working together in the foreclosure world in Florida. What did we meet in 2009 or 10?
I think 2010. Yep.
Right there in the heart of the world. So you have seen it all in your decade and a half, or us in our decade and a half working together. We if we have any questions, we'll interject them along the way. But let's go to town. We're going to introduce you to the. This is an overview of Florida foreclosures. Go for it.
Great. Thanks, Bill. Appreciate the intro. Appreciate our friendship personally, and enjoy working together professionally as well. Proud of you and all you've accomplished, and looking forward to what you accomplish coming up in the near future, the long-term future for you and your fund as well. Happy to help and be a small part of the team.
Yeah.
I am here to represent Howard Law and give a brief overview of the Florida foreclosure process. Um, we have been doing foreclosure work in Florida for about 12 years. We recently opened an office in Georgia doing the same kind of work. We are full service in the default space, doing mortgage foreclosure cases, bankruptcy work on behalf of creditors, eviction work, and REO closings as well. Here's our contact information. Um, and again, here's a little bit about the firm and myself, which I pretty much just mentioned. Our firm solely responsible for working default space, representing plaintiffs and lenders in litigation matters and closings throughout the state of Florida and Georgia. We are problem solvers. We try to resolve the loan that's in default as opposed to unnecessarily litigating over it. We're ethical, aggressive, able to litigate, but always with a mind on getting the loan resolved via some type of settlement, loss mitigation, loan modification, deed in lieu, consent to judgment. So always important to continue to revisit those settlement opportunities that
You learned
come up.
that from me. I want to take credit for that.
A little bit of help from Bill and the win-win strategy that he wrote about in his book. Yeah.
That's good.
Here's a brief overview of the areas of law that we practice. Like I mentioned, mortgage foreclosure litigation, both contested and uncontested. We have attorneys here that are able to move a file from beginning to end when the borrower does not respond, and as well as cases where the borrower is contesting us with a sophisticated defense attorney. Our trial lawyers are able to handle those files as well. We handle real estate and title closings throughout the state. We represent creditors in bankruptcy matters, actions for possession, such as eviction and ejectment. We handle some tax deed surplus and actually foreclosure litigation surplus matters as well, and association issues, along with some various other areas. Our firm is Fannie Freddie approved in Florida, receiving the no objection. We've received a Fannie no objection in the state of Georgia and are pending the Freddie no objection. We follow the Fannie guidelines for billing purposes and milestone purposes. So that keeps some uniformity in how we operate with the servicers and some other investors. So now getting into a little bit of the nitty gritty of note and mortgage and what Bill and his team and many other investors out there are actually buying. There's two loan documents amongst many others that are important when a loan is originated. One is the promissory note, which is a negotiable instrument generally, and it is defined as the promise to pay money back. It is related to money. The security instrument that encumbers real property is the other loan document called the mortgage or deed of trust in some states. In Florida, it's called the mortgage, and that operates as a lien encumbering the real property. That lien can be in first position, second position, 10th position. Bill and his team often focus on first position liens. There's other funds out there that focus on second position liens, and sometimes a hybrid of both, depending on the operation. This slide is a brief overview of the entire foreclosure process, from pre-foreclosure all the way through getting a judgment, a foreclosure sale, any post-judgment issues that come up, and everything in between, which is obviously very important. The last bullet point on this slide, which is the goal, is getting clear and marketable title to the plaintiff lender. So if we do everything right, we are able to review title, name everyone we're supposed to name in the lawsuit, eliminate any junior liens, and get the plaintiff clear title via certificate of title so they can sell the property.
Let's take a moment for those, because some of this conversation is going to be on our podcast, and I want to read through for that audience the foreclosure process as we know it in Florida, so that you get, and this is to give everyone really a sense of what the process looks like and why judicial states, and remember, Florida is one of those ones that fall into the judicial foreclosure process, why judicial states are a little more difficult to operate in as a lender. And that is pre-foreclosure is the start, right? And during the pre-foreclosure process, when the borrower stops paying, at the same time they're making a referral, the servicer is now making a referral over to the attorney to start a pre-foreclosure process, probably while there's last-ditch efforts to do modifications or something at the servicer. At that point, the attorney has to ensure the standing of the loan, has to set. There's got to be a default letter sent out. Either the attorney firm or the servicer does that. There may be requirements by HUD or FHA or Ginnie Mae, GS, or one of the GSEs if you are talking about a government-insured loan. There's the title commitment that Harris's office has to review. This is all before they even file the foreclosure, which the first thing to do, this first step of that is the complaint. After the complaint is filed, you go through service of process. You actually have to deliver that complaint to the borrowers in question. You have to give a period of response from the defendant, aka discovery, also discovery. Then there's the motion for summary judgment, which is the most common way of getting a judgment against the property. Or you can also have a trial. So that's the process of creating the final judgment of foreclosure. And that step is followed by foreclosure sale, 30, 60, 90 days thereafter. Then you review any post-judgment issues, because even after you've gone through a sheriff sale, there might be something that you've got to go back to the title company, right, Harris, and get them to get to that goal, which you then just talked about, which is clear and marketable, insurable title.
That's right. And great job, Bill, on talking about the overview. The rest of the presentation is really just an expansion on each of these topics in a lot more detail. So Bill did a great job of the overview and the summary, and then we can get into a little bit more details on each of them as we proceed. So as Bill mentioned, before we file a lawsuit, after the borrower is in default, we need to make sure that the lender and their collateral allows us standing to file a lawsuit. So we need to prove to the court, does the plaintiff have standing to foreclose the mortgage at the time the complaint is filed, and can we prove it to the judge and overcome any defenses that a borrower or their counsel may raise. In Florida, the key to the standing is securing original loan documents. So having the original note endorsed to plaintiff or endorsed to the order of blank generally wins the day. And if you have that, we generally don't have a standing issue. We often prefer to also have the original mortgage, but not as important. Again, the original note endorsed to plaintiff or to blank is the key to the case. There's other documents and evidence that's able to be used to prove standing. In certain instances, simply being in possession of the original note may not be enough. So we rely on other evidence such as Bailey letters, which are letters signed by attorneys or vendors or servicers saying who's in possession of what and when they became in possession of it. Recorded assignments of mortgage are often additional evidence to confirm standing. Sometimes those assignment of mortgage will reference that the note is transferred along with the assignment of the mortgage. Oftentimes, we may not be able to have possession of the original note, and Florida has a statute and some rules of civil procedure on how a lender can still enforce their loan documents even if they do not have the original note. We would obtain a lost note affidavit signed by the servicer or the investor that must meet the Florida statute on point, section 673.3091, and the rule of civil procedure, rule 1.115, paragraph D, which basically outlines the requirements to be met in order to enforce the loan documents when you do not have possession of the original note. The lost note affidavit and the facts and defenses surrounding the lost note affidavit are one of the most highly contested areas of a foreclosure case in Florida these days. Many of the other laws have been changed and are very well settled these days. But the facts surrounding not having possession of the original note are often highly litigated. And it's very important that we have a solid lost note affidavit at the beginning of the case, which will make the rest of the case a lot easier and perhaps avoid some unnecessary defenses, litigation costs, and equally as important, the time element to overcome some of those issues. Simply relying upon a prior servicer's lost note affidavit is not always the best idea. Our office does a thorough job of researching to see if we can actually find the original note, and if not, researching the lost note affidavit that may have accompanied the loan on the loan sale transaction to an investor like Bill. If it satisfies the requirements that are necessary in Florida, great. If not, we'll draft a new lost note affidavit, add some additional facts that we've learned, and get it compliant with the rules to allow us to proceed to file a complaint to not only foreclose the mortgage, but also to reestablish the lost note. This next slide is the specifics of the Florida statute that's on point and what's required to be included in the lost note affidavit, and more importantly, to prevail on a count to reestablish a lost note. So if you're interested in some legalese, feel free to read the statute. Similarly, here's the rule of civil procedure on point that I referenced regarding pleadings in a lost note affidavit situation. As I mentioned, many of the other areas of law in Florida have been settled. This next slide is on statute of limitations and default date. This is one of the areas that has been well settled. Thankfully, we do not operate like some of the other states, including New York, that have a bit of a mess dealing with these types of fact patterns with an old default date. The law in Florida is pretty well settled that the statute of limitations is no longer a major issue. I would make sure that your complaint states that the loan is in default for non-payment on a specific date and include language all subsequent payments. This allows you to proceed with the default date. Really, that's any date, so long as you can prove the case that there was actually default, that no payments have been received past that default date to move the default date. So no real statute of limitations issues anymore. Then we get into the default letter, which is probably the most highly litigated area of a foreclosure case in Florida. This is discussed in the pre-litigation section of this presentation because it's something that we generally verify before we file a suit, but it does often become a highly litigated defense in the borrower's answer, argued at a motion for summary judgment and or trial. The essence of the requirement is that paragraph 22 of most Fannie Freddie mortgages require that the lender give notice to the borrower before accelerating the loan that they're in default and an opportunity to cure the default. The A, B, C, and D in the mortgage, which varies a little bit by mortgage, but generally contain the same language, need to be in the notice. The standard for the letter is that the lender must substantially comply with paragraph 22, which is not strict compliance. So that gives the lender and the servicer and the plaintiff's counsel a bit of leeway to comply with paragraph 22 and make sure that the default letter complies with what's required. Again, not every mortgage has this requirement, so be sure to review your mortgages to see if a default letter is even required. If it is, and it needs to be sent before you file a lawsuit, make sure you do that. If you don't, you will lose your lawsuit. Sending this default letter is a condition precedent to filing the action, and if it's not done, you cannot win your case. Again, since this is a highly litigated issue in Florida, some of the most common defenses and how we overcome them are addressed here. So oftentimes husband and wife may be on the mortgage and a notice of default is required, but only the notice is provided to, for example, wife. The mortgage generally has paragraph 15, which says notice to one borrower constitutes notice to all borrowers. So that overcomes the issue of only sending the notice to one borrower. Best practice, we often send to both husband and wife in that example, regardless of there being a paragraph 15 notice to one is notice to all. But it is nice to have the ability to rely upon paragraph 15. Oftentimes we'll get a defense that the borrower did not receive the default letter, but that is not the standard. The standard is that the lender send or mail the default letter by first class mail, and not necessarily that the borrower receives it. So as long as the lender can prove that it was sent, that should satisfy the condition precedent. It's important for lenders and servicers to know where this default letter is going. Generally, on a owner-occupied property, the borrower's address is the physical property address, but we should all be mindful of the borrower moving and providing written notice to a lender or the servicer that they want to receive notices at a different address. And if that happens, that default letter needs to go to that new address, and make sure you're aware of that possibility. If the sending of the default letter becomes contested, we would need to get evidence from the servicer. Oftentimes the green card is used, or records of the servicer to prove that it's the regular business practice to send the default letter to the borrower on X days after default and to the correct address. Business purpose loans are a big product out there right now. Most of the business purpose loans waive the pre-suit notice. So that's a nice benefit of the business purpose loans. Never a bad idea to still send the letter, perhaps engage the borrower to try and settle the case, but it's not required or condition precedent to the filing of a lawsuit in a business purpose loan setting most of the time. As Bill mentioned, there's some HUD or government pre-foreclosure requirements that are specific to that type of loan product. They're pretty unique. There's been a bit of a law change as it pertains to the HUD face-to-face meeting and requirement before foreclosure can be filed. Earlier this year, actually, the FHA temporarily waived the requirement and is allowing for alternative methods to conduct the meeting, which is definitely helpful to servicers and borrowers, and allows for a more productive and more recent technology advances way to communicate with the borrower rather than physically sitting in the same room. So after we've confirmed we have standing and we know we have a good default letter, we get involved with a title company that provides us with a title commitment. We order the title commitment from a third-party vendor who produces a product to us. And this title commitment provides a roadmap for us as lawyers to determine what needs to be done to obtain and reach the goal that I mentioned earlier, which is clear and marketable title. The title commitment provides requirements that need to be satisfied in order to complete the foreclosure case and issue an owner's title insurance policy to the property owner after the foreclosure case. Some requirements that are included in the title commitment are the necessary parties to the lawsuit, which would be the buyer, the owner slash borrower of the property, which hopefully is the same, but oftentimes may not be. So the borrower, the owner, any junior liens that attach to the property that need to be eliminated. For example, credit card debt or association lien needs to be included in the lawsuit and eliminated so that we can obtain clear and marketable title. And then sometimes there's additional counts that are referenced on the title commitment that need to be included in a lawsuit. If there's an issue with the legal description, for example, we would be asked to reform the legal description and have account for that in our complaint. So once we've reviewed the title, the default letter, and the collateral, and we're comfortable moving forward, the attorneys in our office will prepare a complaint package, which is 5 different documents that collectively make up the complaint package. The first of which is the actual complaint. It's the initial pleading setting forth the claim for relief that we're asking for. Usually it's 1 count for mortgage foreclosure, which is asking the court to allow us to foreclose the mortgage lien and take title of the property via foreclosure sale. Additional counts that can be included in the complaint are breach of note, reestablishment of a lost note, like we spoke about, reformation of the mortgage, and other causes of action related to title issues as well. We're seeing a lot of personal guarantees and UCCs also in the business purpose world. So those are some additional counts that are included in that type of loan product. The second document that's part of the complaint package is the lis pendens. This is notice to the world of the pending litigation, which is a document recorded in the public records where the property is located. So that once that document's recorded, the whole world is deemed to be on notice of the lawsuit and sort of beware of dealing with that property, whether as a lender or a subsequent buyer, because there's litigation surrounding it. The lis pendens also serves to cut off additional encumbrances from attaching to the property. So if the lis pendens is recorded today and American Express has recorded the judgment against the property tomorrow, the lis pendens that's recorded today serves to cut off that American Express judgment. The third document is very important, certificate of possession of the original note. If we have the original note, it's generally signed by the plaintiff law firm and shows that the plaintiff has possession of the original note at the time we're filing the complaint. This is very important because if we are able to then produce the original note that's in the same condition that it looked like when we signed the certificate of possession at the filing of the complaint, if we produce the original note in the same condition at the judgment hearing, we generally don't have any standing concerns. The fourth document that's part of our complaint package is a civil cover sheet, tells the clerk of the court what type of case is being brought. And the fifth document is the value form, which estimates the value of the claim that's being brought by the plaintiff and determines how much money the clerk of the court gets upon the filing of the action. This next slide gets into some of the details of what's actually included in the complaint. It should include specifics as to the specific loan, the specific property that we're seeking to foreclose, the date the note and mortgage were originated, if there's a modification of the mortgage, recording information of the mortgage, legal description, who the owners of the property are. Capacity of the plaintiff is a big one. Again, do we have possession of the original note or is the note lost? Is stated as an allegation in the complaint. We state that all conditions precedent have been met, such like we spoke about earlier regarding the sending of the default letter. We make sure to include that the loan is in default and that the loan has not been paid for a date certain, and all subsequent payments, I think, is very important language to include in your complaints. The complaint accelerates the balance due and requests attorney fees and costs. And then the body of the complaint names all the necessary parties that were identified on our title commitment and their respective interests to make sure that we're eliminating the interest of the party. There's a prayer for relief at the end of the complaint, asking the court for a judgment of mortgage foreclosure and for the court eventually to schedule foreclosure sale and auction the property. In Florida, the complaints need to be verified. So generally the loan servicer will verify the contents of the complaint, sign it and notarize it, and then send it back to us, and we will get it filed along with the exhibits to the complaint, which are generally the note, the mortgage, any modification if one exists. Sometimes we include the assignments of mortgage, and sometimes we include the default letter. Once the lawsuit is filed, the lawsuit needs to be served via process server, whether private or sheriff, on each defendant, informing them of the lawsuit and requiring them to take action in response to the lawsuit should they choose. There's 4 general ways to serve process, personal or individual service, which is our favorite. If we have a good address for the individual we're trying to serve, our process server should have no issues getting them served. If you want to obtain a monetary judgment, personal service is necessary. Oftentimes, we're not able to obtain personal service. We obtain substitute service, which is service on an individual at the defendant's usual place of abode with a person that resides there who is at least 15 years old. I know that's a lot to say, and it's very specific, and that's intentional. The service of process laws in Florida are require strict compliance, so it's important that every element of the rules are met and satisfied. I know Bill and his team and many of the investors out there are dealing with a lot of the HUD HECM loans, which oftentimes have a deceased borrower and lots of heirs, and that leads to some service issues, whether we can't find some of the heirs or are not able to serve them for whatever reason. We then often resort to service via publication, which is when we cannot find an individual to personally serve, or maybe someone's avoiding service, we serve via publication. In the HUD HECM world, when there's a deceased borrower, service via publication also is accompanied by a guardian ad litem, where we appoint a neutral third party to represent the unknown parties, and they will file a report and an answer to let the court know what was done or what has been done to find the unknown parties and identify them if possible.
And really, if you have to say, if in my experience of almost 2 decades now, working through this process, when the courts were full, when the courts were empty, either way, this is probably the biggest chink in the chain on your timelines. This and bankruptcy maybe, but I would say bankruptcy, at least you have an end game. What are there any tricks to the trade? Because like for instance, you hit the nail on the head with these HECMs. We've got situations where you've got 22 dozen heirs outside of the country, like especially in South Florida, you get, a dead person in Miami has 36 relatives in Cuba. What you're just doing publication service? Are there any tricks that you guys use to speed that process? Maybe there's something we should be doing more as investors to try to go after those? Any ideas on that?
Yeah. Well, I think it's both. I think the investor getting as much information to the lawyer as possible is obviously helpful. And I know the investor doesn't get a ton of information from HUD, so that's easier said than done. But the investor engaging third-party vendors to determine where these heirs are would definitely help the attorneys do their job. We also recommend doing an heir search before we file the lawsuit. So we generally start with a decent base of who the heirs are and where they are. That often proves easier said than done. So if there's 22 defendants, maybe all the information we get from the heir search is not accurate, and we're able to serve 14 personally right away, but then we still have 7 that creates the delay, or even 1 that creates the delay.
That's the irony. That's what makes it so weird, is that once you could have one holdout that you can't find and you're still stuck in a publication process. And what is that, like a 6 to 9 month extension sometimes?
No, so there's some work that needs to be done before you can actually publish. You need to attempt service via personal service, and then once you've attempted the required number of times, you go service via publication. It should be 60 days, maybe 75 days, depending on the county and how quickly we're able to publish. And the response period is 30 days, which is included in that period of time.
Just from an asset management point of view, Marty, or anyone else that's listening to the recording, this is when we come across these, this is the flag. Let's go sell the note. That I gave away a little bit of the secret sauce there to the world, but whatever. Okay, go on.
Yeah, I mean, and many note buyers would find value in that because they don't mind. They know the game. They know the timeline.
Yeah, they want to own the real estate. For them, it's not about time. For us, it's like, if we know this is a tail, even if there's profit in it, why not take that cash off the table and redeploy at the way that we're growing in size? And the more assets we take down, that's just feeding our other friends in the market too. It's a win-win.
Yeah. Yeah. Once the party is served, the process server will file a verified return of service with the court. And after service, via personal or substitute, the defendant has 20 days to respond. Service via publication allows for 30 days. Something Bill and I just touched on, the timeline and expense to complete service depends on the initial information we're getting. But even in a non-HECM situation, perhaps as a business purpose loan where there's an entity and the investor knows that this entity maybe is defunct, or they created a shell entity and the registered agent doesn't really participate, service may become a challenge, and the more information we get from them, the better. But in the business purpose world, when the entity is a borrower, the borrower entity has to have a registered agent in Florida, and we're able to serve the registered agent, and generally that is done pretty quickly. The challenge to service a process is done through a motion to quash, if appropriate. This is where a defendant objects to being properly served. And as I mentioned, the service of process statutes in Florida require strict compliance. So we need to make sure that us and our process servers are doing things 100% accurately. So after the lawsuit is filed and within the 20 days, a defendant has the opportunity to respond to the complaint. If they do not respond to the complaint, we file what's called a motion for a clerk's default, which is where we ask the clerk of the court to enter a default without a judge or a hearing being present. If the defendant's an unknown party, unknown tenant, or an unknown spouse, or some paper was filed on behalf of a defendant, the clerk may not enter the default, and we then ask the judge to enter the default via what's called a motion for a judicial default, which does require a court hearing and the participation of a judge to enter the order. Once a default is entered, whether via clerk's default or judicial default, it means that all of the allegations in the plaintiff's complaint are deemed to be true. If a defendant does file a response, one of the responses could be a motion to dismiss, which is oftentimes the initial motion that a borrower files, sometimes merely for delay purposes. Sometimes there's more merit to it, and that depends on the borrower, the loan, and oftentimes the defense counsel that's representing the borrower. The motion to dismiss is considered by the court, and the court is considering it, and it's limited in its consideration to reviewing the allegations within the four corners of the complaint as if they're true. The court must take the facts pled in the complaint as true and not consider how the facts will later be proven. Defendants often raise offenses in the motion to dismiss, which are not appropriate, just like standing and conditions precedent. Again, not appropriate for a motion to dismiss, more so for an answer and affirmative defenses. So if a defendant does file a motion to dismiss, we would set it for hearing, and the judge would make a ruling either granting the motion to dismiss and giving us an opportunity to amend the complaint should the facts arise for that, or more likely they would deny the motion to dismiss and give the defendant 10, 20, or 30 days to file an answer and affirmative defenses to the complaint. So the responsive pleading or the answer and affirmative defenses is the first pleading that's filed in response to the complaint. The answer part of the responsive pleading is a response to the allegations contained in the complaint. So the paragraph 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, etc. are responded to individually by the defendant, whether they admit the allegation, deny the allegation, or are without knowledge as to the allegation, again, specifically as to every single paragraph in the complaint. And then oftentimes that answer is accompanied by affirmative defenses, which is the legal ground as to why the plaintiff is not entitled to the relief it is requesting. There's 2 rules of civil procedure that govern the affirmative defenses and state that they need to be, the defenses need to be pled with specificity and particularity. Simply denying performance is not enough to create an issue of fact. I touched on some of these in our presentation about what we do before we file the complaint and with the filing of the complaint, because our office analyzes these things before they actually become defenses. But some common affirmative defenses that we see are standing, related to the loan documents. Possession of the original note, again, is very important. Conditions precedent, paragraph 22 default letter, again, very common affirmative defense. Statute of limitations, not as common anymore, but often still raised, but easily overcome. Accounting and pay history are affirmative defenses we see. Can you prove the amount that you alleged owed is actually owed? And then if there's a long chain of endorsements to the note, did the person signing the endorsements have the authority to do so? Some additional affirmative defenses here: failure to state a cause of action, unclean hands. If it's a HUD loan, maybe there's some defenses related to that. Sometimes there's FDCPA or FCCPA violations, which are lobbed as affirmative defenses. Failure to mitigate is another one that we sometimes see. If there's a condo or homeowners association that governs the property, they'll often file and answer affirmative defenses related to claiming surplus funds, if there are any. Safe harbor, which is a term of art in Florida related to money that's owed to the association, which I have some separate slides on later in the presentation. And this is not an exhaustive list. There's lots of maybe other affirmative defenses that are raised, but those I think are just the most common one. So it's important for the plaintiff to be able to overcome each of these affirmative defenses. So if we see an answer with affirmative defenses filed, we need to make sure that we can overcome them, and we'll do whatever research we need to with the investor and the servicer to get records or evidence to overcome whatever the specific defense is. Oftentimes in a contested case, discovery will happen. This is pre-trial, and either party has the option or opportunity to do it. It's an attempt to obtain evidence from the other party, generally in three forms: request for production of document, which is when one party is seeking documents in support or opposition of one's position, and you produce whatever is in your possession. If you don't have it, it's a fine answer. Another form of discovery is interrogatories, which are sworn statements, sworn responses to statements. The third and most common discovery method is request for admissions. Admit that you signed the loan document on June 1st, 2023 is an example of a request for admission. Very important to timely comply with the request for admissions. If the request is not timely complied with and responded to within 30 days, the request is deemed admitted, which we don't want that to happen if we are the responsive party. Oftentimes, a request for admission or a request for production of document is objected to for various reasons. It could be privileged, attorney-client, work product, or just being overly broad and not likely to lead to discoverable evidence. If no information is provided in response to some of these discovery requests, or poor information is provided, one of the parties or the filing party can file a motion to compel better answers or answers to begin with if no answer was filed, a response was filed initially. Finally, in terms of discovery, deposition can be taken. So this is when one party asks another party questions under oath about the facts of the case. Once the case becomes at issue, meaning every party has been defaulted or filed an answer, the case is at issue and we are able to proceed with a motion for summary judgment or a trial. Many investors and servicers prefer the motion for summary judgment opportunity, and this is an opportunity for us as the plaintiff's lawyers on behalf of the plaintiff to obtain a final judgment based on the pleadings, discovery, and affidavits filed in the case. The standard for summary judges in Florida changed recently, and the court now adopted the federal court standard, which is, I think, more plaintiff friendly. It directs the court to grant summary judgment if the movement shows there's no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. The non-moving party, which in our case we would be the plaintiff moving party, the defendant borrower would be the non-moving party. The non-moving party now has the burden to produce admissible evidence to support their defenses to overcome our summary judgment. And another important change to this law a few years ago is that the summary judgment must be served 40 days before the hearing. So there's a bit more time that's required in between the filing and the actual hearing.
And this is another pivotal part of the foreclosure process, as I recall. You know, the when we were dealing with a lot of folks who were kind of gaming the system post GFC, the motion for summary judgment sometimes became not a good approach to take, but rather, you know, we would go directly to a trial because we knew they were going to answer. We knew that they were going to raise some issue, albeit BS, that would, because the bar for MSJ was different then, that could then throw it from an MSJ hearing into a trial anyway. So, you know, that's kind of now changed, as I understand, with some of this changing here. And there's also a lot less shysters, I guess, out gaming the system these days. Who knows?
I'm not sure about that, but the standard change has definitely helped us as plaintiffs' counsel. We also have strong affidavits that are used to overcome defenses oftentimes. And it's really fact specific. Sometimes there's a case, many lost note affidavit cases, or depending on who the borrower's counsel is, we may not waste the time or money with the summary judgment and just go directly to trial. It'll save, 4 months or 5 months and some money dealing with the summary judgment, just go right to the trial.
Yeah, so it does something, and you think about those things. In general, though, going to a trial versus a summary judgment will cost more. But if you know you're going to end up there anyways, just skip the MSJ process and go straight to trial, is what you're saying.
Sometimes I think it's appropriate. Yeah.
Yeah.
Agreed.
Okay.
So another couple of slides on obtaining a judgment via the motion for summary judgment. Like I mentioned, we have affidavits in support of the summary judgment. The most common one is the affidavit of indebtedness, which is generally the servicer, but could be the investor signing a sworn statement as to how much money is due, and also including any other statements to overcome defenses, such as standing issues, default letter issues, payments, etc. Anything fact specific that needs to be in the affidavit to overcome defenses is included in the affidavit. Another affidavit in support of summary judgment is affidavit as attorney's fees and costs, and a neutral third party's affidavit of reasonable attorney's fees. Once the affidavits and the motion are actually filed, the defendant has an opportunity to respond to the summary judgment via a response, a memorandum, or their own affidavit in opposition to the motion for summary judgment. And there's some recent law changes that actually require an affidavit in opposition to truly possibly create an issue of fact that would overcome the plaintiff's motion and actually create an issue of fact where the plaintiff's motion for summary judgment would be denied. So once, as I mentioned, once the motion's filed, the hearing cannot be for a minimum of 40 days out. And then at the actual hearing, the plaintiff's law firm will present arguments as to why there's no genuine issue of material fact, and ask that the court enter the final judgment. If the judge agrees, summary judgment is granted. The original note and mortgage, if you have it, is tendered to the court. The note is stamped canceled, so it cannot be later put into the stream of commerce and enforced again. And the judge will enter a final judgment of foreclosure and also rule upon any other counts that we have in our complaint, if we do have any other counts. And that final judgment of foreclosure schedules a foreclosure sale. Before we get to the actual foreclosure sale, as Bill and I discussed before, if we don't feel that summary judgment is appropriate or we lose our summary judgment hearing, we can also obtain a final judgment of foreclosure at a trial. And the goal of trial is similar to obtain a final judgment, but it's based on witness testimony and evidence as opposed to the pleadings of the case. The trials are generally done before a judge, and especially in foreclosure actions. And at the trial, we present evidence such as the original collateral, proof that the default letter was sent, the pay history to prove our case. We have a witness from the servicer generally, and perhaps prior servicers as well, if necessary, that testify based on their personal knowledge about whatever specific allegation or defense is being addressed. Hearsay is a common objection that defense counsel raised regarding the admittance of evidence, and that's an often evidentiary issue that is dealt with by the trial lawyers at the actual trial. I don't need to go through all these, but here's a basic script of some questions that are asked of the service or trial witness that allow for the plaintiff to prove their case at a trial. Again, the hearsay objection is a common objection raised by borrower's counsel. It's often overcome by the business record exception to hearsay, an evidentiary term of art that's commonly litigated over in foreclosure trials. And here's a bit of information about those objections and the exceptions and how to overcome the objection and get our evidence into the record, so it could be considered by the court and hopefully used to prove our case. So whether you obtain a judgment via motion for summary judgment or after a trial, a final judgment is entered, and that final judgment determines the amount of the debt that's owed by the borrower to the plaintiff and schedules a foreclosure sale. At the foreclosure sale, there's really two options for the sale. The plaintiff lender will determine the maximum bid, and if a third party bids more than that number, the third party gets title to the property, and the plaintiff gets the amount of money that was bid over their maximum bid. And if no one bids more than the plaintiff's maximum bid, the plaintiff will get title to the property, and hopefully that title to the property includes clear and marketable title, such that they can go and sell the property the next day on the open market. Given the equity position of real estate, specifically in Florida, there's a lot of litigation these days about post-judgment advances. So if a judgment was entered 3 months ago and then the servicer pays real estate taxes and insurance premiums, or the judgment was entered 2 years ago and the borrower filed bankruptcy, we've been in and out of bankruptcy for a few years, the amount of money that's owed to the lender could change from the date the original judgment was entered, and we have a lot of litigation surrounding that. So we include some language in our judgment that allows us to seek post-judgment monies, interest advances, like I mentioned, escrow advances, taxes, insurance, property preservation, and motion and attorney's fees and costs. Given the amount of litigation, we're often these days moving to amend the final judgment with a supporting affidavit, and this is oftentimes determined by the servicer with our input based on a case-by-case basis. If there's no equity in the property, then there's no sense in increasing the total debt, because if the judgment is more than the value of the property, no sense in increasing it. But given the equity position these days, there often is equity, and it would make sense for the lender to be able to capture every penny of the debt that they possibly can. So a little bit about the foreclosure sale. We publish notice of sale in a newspaper. Like I mentioned, the plaintiff sets the maximum bid, try and get us the bids as early as possible. Oftentimes, servicers are a little delayed in doing so. Many of the sales in Florida are done on an online auction, and we will handle the online platform, inputting the bid, the vesting information, etc. And then when the bid happens, like I mentioned, if the bid is met, plaintiff gets the money and the third party gets title. If the bid is not met, the clerk of the court issues certificate of title to the plaintiff between 11 and 30 days after the foreclosure sale. Within that 10 days after the sale, there's an objection period where a defendant can object to the sale, and we have some litigation surrounding that. Our firm is very big on settlement. I believe it's always better to settle your cases. Litigation is not always the best method. While that may conflict with lawyers making money, I believe less litigation fees leads to more money in the lender's pocket and the ability to go buy more loans and send us more referrals. So we're very big on settling our cases, both before we get before we file a lawsuit, if we're able to engage with the borrower or borrower's counsel during a lawsuit, all the way through the eve of a trial. If we have the ability to settle a case, we're trying to do so. Various means to do so: deed in lieu of foreclosure, mortgage modification, consent to judgment, We can also participate in a mediation, which is when we have a neutral third-party mediator tell us our pros and cons of our case and tell the borrower or defendant the pros and cons of their case, and hopefully bring us to the middle ground to reach some kind of settlement. Often helpful. Once a lender has title to the property, there may still be additional issues to deal with. Were there any superior liens that need to be dealt with? One may be a water lien. Water liens are often, not often in Florida, are always superior to the mortgage. Are there any municipal violations that need to be dealt with? Just because you have title to a property does not mean you have possession to a property. So we may need to file an eviction or an ejectment action. Deficiency judgments are a big topic in the business purpose world, especially when there's a personal guarantor. In Florida, you have a 1-year statute of limitation to pursue that. And then the investor with their servicer and other vendors should make sure the property is preserved now that they own it, maybe get insurance on the property now that they own it. Other post-judgment issues that come up relate to condo and homeowners association. That's an important issue to deal with in Florida. Associations could be owed a lot of money, and I have a couple slides on that to talk about. As I mentioned earlier, safe harbor is a common term of art that's litigated by associations. The dealing with the association's post-certificate of title is all about how much money the association is owed. Oftentimes a borrower, when they stop paying their mortgage, they may have also stopped paying the association, and the association could be owed 10 years of maintenance and assessments. And the question is, how much of the past due arrears does the first mortgage lender now owe to the association? Florida statute section 718.116, also known as the safe harbor protection, states that the lender is only required to pay the condo association the lesser of 1% of the original mortgage amount or 12 months maintenance. So this reduces the amount of money that the association may be owed from, for example, 10 years of maintenance to the lesser of 1% of the mortgage or 12 months maintenance. And that's, again, sort of the worst case scenario, so long as you meet the criteria of 718. Oftentimes, there's a best case scenario where the association declaration may include an inferiority clause saying that a first position institutional lender owes the association nothing. Unfortunately, not every association and their counsel recognize the safe harbor protection, so that leads to some litigation or discussion surrounding the amount of money that's owed. Oftentimes, these get settled via just monetary offers between the parties. Florida also has homeowners associations, which differ slightly from condo associations, and that's the statute that governs homeowners associations is in Chapter 720. Very similar guidelines to obtain the safe harbor provision. Here's a few examples of safe harbor. Don't need to really go through the example. As I mentioned, deficiency judgments are a big topic, especially in the business purpose world, and it allows the lender to pursue the deficiency amount against the borrower when the sale price is less than the total debt that's identified in the final judgment. The burden's on the plaintiff or the lender to establish the value of the property. There's a presumption that the third-party bidder paid fair market value for the property. The borrower could shift that presumption and challenge the value by introducing evidence to establish a different value. Various factors to consider about whether you want to pursue it and how to go about pursuing it, whether within a foreclosure action or a separate action. And simply obtaining a deficiency judgment is only a small step in the real battle. Collecting on the judgment is, I think, more important if that's the route that the servicer wants to take. And collecting on the judgment may include discovery, depositions, garnishment, and levy of assets. Oftentimes, loans are bought and sold while there's already a pending foreclosure case. Our firm has a lot of experience transferring into a lawsuit after that transaction where the loan is bought and sold, but there's already a pending lawsuit filed. We ensure there's no delay when substituting into a case. We immediately request the case number, review the pleadings, get a status of the lawsuit, figure out where the original collateral is, get a title update, and we'll try and provide the servicer and investor an update on the file, where the file is, what needs to be done to get to judgment, if it's contested, any documents or evidence that we need to obtain to overcome the defenses, and a budget on how much it should take for us to accomplish that. Transferring to a lawsuit also may include the filing of a motion to substitute the party plaintiff. So if Bank of America originated a loan and they're the plaintiff in a lawsuit, and then Bill's fund buys the loan during the lawsuit, we would need to substitute Bill's fund into the lawsuit as the party plaintiff, and doing so via motion is how we accomplish that. As I mentioned, business purpose loans are very hot loan product out there these days. We have a lot of business purpose loan files in our office today, and we see that portfolio growing quite a bit. The process is generally the same when we foreclose a business purpose loan as it is a regular non-performing Fannie Freddie loan or a HECM loan. Business purpose loans can include mixed use, fix and flip, new construction, single family rental. So the process is generally the same. It's the only difference really is the finances and how default interest may be calculated, or if there's a construction holdback on the construction loans that need to be separately identified on in our affidavits. The business purpose loans, since they're non-owner occupied, they allow for some additional leverage by the plaintiff. The order to show cause statutes in Florida allow for a bit of a fast track foreclosure litigation, and you're asking for an evidentiary hearing to enter a final judgment a bit earlier in the process than you otherwise would. Some additional leverage that you have with business purpose loans, the loan documents generally include an assignment of leases and rents, which allows the lender to seek to have leases and rents transferred and deposited to the lender instead of to the borrower who's in default with the loan documents. So we often file motion for assignments of leases and rents and have a hearing on that, and are pretty successful, very successful in obtaining an order assigning leases and rents. Again, you run into a compliance issue sometimes where the tenant may not comply with the court order and actually transfer rents to the lender, but we can go and enforce that order should we choose to do so. In bigger commercial properties, the ability to obtain a receiver being appointed to govern the property is often available to us in the business purpose loan documents, and may be appropriate, like I said, in some more expensive high value loans, or bigger loans that have more units, true commercial multifamily with 50 doors or something would be a good example of that. The standard to appoint a receiver is if waste is being committed at the property. Some other things to consider about receivership can be expensive, as there's many different vendors that require that are needed to be part of the process. The actual receiver, an attorney for the receiver, an accountant, maybe a management company. But I think the goal of both of these, the assignment of leases and rents and a receiver, are hopefully to entice some type of settlement between the lender and the borrower.
What's the timing delay when you are going in? Is it a consideration for investors that, well, maybe it's not worth the going for the, or is it something that can be done simultaneous with other parts of the process? Can you just talk about that?
Yep. So I think the answer is both. We can and often do file a motion for assignment of leases and rents with the filing of the complaint. So it's done simultaneously and can be obtained as quickly as possible. Oftentimes, we actually wait until we have service of process and we know there's tenants in the property to seek rents and leases from. And again, the more information we get from the servicer investor about the specific property or loan, the better. And that may dictate, and oftentimes does dictate, when and how we go about seeking the assignment of leases and rents. And if we find out late in the game, when the case may already be at issue, that there's tenants, or that the lender wants to go and seek assignment of leases and rents from the tenants, we may already be at the summary judgment stage, and it may not necessarily make sense to spend the time or maybe delay our motion for summary judgment hearing just to have a motion for assignment of leases and rents heard if it needs to be heard separately.
Right.
So those timing elements are important and are considered, and are really servicer and even more specifically, investor-driven, investor by investor, even at the same servicer shop. It's a good question, Bill. In business purpose world, there's a lot of loans that are cross-collateralized, which present some interesting discussions with the servicer and the investor. And we have a lot of experience handling those types of loans. It's important to remember there's one debt in that situation, multiple mortgages maybe, but one note and maybe one mortgage that encumbers multiple properties. And then each property is sold separately at a foreclosure auction. I added a couple slides special for Bill. He's big in the HECM world, and I know there's a HUD HECM portfolio of loans being sold shortly, so many of you out there may be interested in this. We represent Bill and several other investors in the HUD HECM reverse mortgage space. And the process of foreclosing a HECM mortgage is generally the same. As I mentioned before, we oftentimes order an heir search before we file the lawsuit. This allows us to identify the heirs before we file the lawsuit, and we will order a title commitment that includes naming the heirs and the creditors of the heirs, which is very important because the heirs become owners of the property, and the creditors of the heirs, there are liens attached to the property. So it's important that those get eliminated as well. Ordering the heir search before we file the lawsuit avoids having to amend the complaint 99% of the time. Huge time saver, and often saves money as well. Allows us to clear title more accurately having this heir search. Another, I think, maybe difference in reverse mortgages, which is not often litigated and maybe not even known by some plaintiffs' lawyers, but the HUD HECM mortgage and the corresponding note. The note is not generally negotiable, so we're not able to simply all the time walk into court in physical possession of the original note and prove what's called holder status. Sometimes we need to prove ownership via other evidence, such as assignment of mortgage that transfers the note, or a loan sale agreement, or testimony of a party. Again, not truly litigated, and oftentimes we're able to prevail proving just holder status. But it's important to be aware that that may not always be the case. Finally, on this slide, as we mentioned, there's often delays in the deceased borrower world where we're not able to serve the heirs timely, and that creates a little bit of delay and the need to serve via publication. In addition to HUD HECM loans, we have experience foreclosing second mortgages. This is a term of a priority. So Bill and his fund focus on first position mortgages. As I mentioned, there's oftentimes funds that focus on second position mortgages, and the process to foreclose the mortgage is generally the same. Oftentimes these second mortgage foreclosure cases are pretty short because we're able to get the case settled via some type of modification or repayment plan. And we're very aggressive, like I mentioned, in terms of getting those and every case settled.